In 2013, the ACLU asked the U.S. Supreme Court to consider the question, who owns our DNA? Sparked by the discovery that Myriad Genetics had patented the BRCA genes and were charging women exorbitant fees for hereditary breast cancer testing, the landmark case set a precedent against the U.S. government selling genetic patents to biotech companies. In the Genome defense, Jorge Contreras, one of the nation's foremost experts on human genetics law, follows the lawyers, scientists, activists, and patients in their battle against corporate greed and government overreach. For today's conversation, Jorge Contreras is joined by Dr. Jessica Mozersky, an assistant professor of medicine at Washington University's Bioethics Research Center.
Hello, I'm Dr. Jessica Mozersky, Assistant Professor of Medicine at Washington University's Bioethics Research Center. On behalf of St. Louis County Library and HEC Media, welcome to our conversation with Jorge Contreras, author of The Genome Defense, Inside the Epic Battle to Determine Who Owns Our DNA. Welcome, Jorge.
Thank you.
So I just want to get started with, some impressions of the book, this is a wonderful and terrifically written book, really about an incredibly important topic, which is patenting and ownership of human DNA. And I think it's a topic that actually many people might not even be familiar with. And you managed to make a story about gene patents fascinating and interesting to read. And this is really a story to me about justice and raising really fundamental questions about who owns our DNA. Can companies own our DNA? And the potential harms, of corporate practices in patenting, especially when it denies women or other individuals access to important tests. So to get started, I'm wondering if you can tell us what motivated or inspired you to write this book.
Sure. Thanks so much, and thanks for the question. So this book began a long time ago, over a decade ago. It took quite a while to come to fruition. And it's a story that I knew something about. I'm a law professor. I study patents and genetics. And so I had known about the patents at issue for a long time, for many years before the case was brought, as did many in the field. And it was only in 2009 when the ACLU brought this case that I really raised my eyebrows, along with a lot of other people, and said, wow, that's interesting. I wonder how that's going to go. And then year after year, as the story unfolded, it just became more and more interesting. And in 2013, the year that it was going to the Supreme Court, I had been following it closely. And I ran a focus group with the group FORCE, of Facing Our Risk of Cancer Empowered, a BRCA mutation support group in Washington, D.C. And the women who were part of that focus group really convinced me that this story is about a lot more than this obscure issue of patent law or even genetics. It's really a human story. This is a story that should be told more broadly.
I want to follow up a little bit because, as you're reading the book, the characters that you describe are so rich and full of detail that actually when you're reading it, you feel oftentimes that you're in the room. You're in the courtroom, you're in the offices, you're privy to these private discussions of these multiple parties. So, as an anthropologist, which is where I'm trained, it's almost like I'm reading your field notes. And I'm wondering if you can tell me a little bit about the research and the process that went into writing this book and how you got these sort of rich and detailed details of what was going on behind the scenes.
I learned as I went along. Again, my training is in legal research, and legal research is actually pretty easy because you mostly sit at your computer and access electronic databases and read cases. And so, but I knew this would have to be something completely different. And One of the inspirations for this book is Rebecca Skloot's remarkable book, The Immortal Life of Henrietta Lacks, which I've read numerous times and which I really admire. Obviously, the story is a gripping and important story, but her in-depth research, her interviews, her field research, I thought was really remarkable. And I thought, that's what I need to do. I need to figure out how to do this. And I kind of became an investigative journalist as part of this. But every place that's described in the book, I went to. I was there personally. I made a point of going everywhere except at the very end. There's a meeting that occurs in the Oval Office, and I have not been there. But other than that, Supreme Court, all the courts, the companies, the places, the ACLU's offices, I was there. So I felt I had to be there. Because I wasn't writing a novel, I was writing about real places. So I met people in person, and in a variety of places. I could crazy stories, and I went back to people with repeated questions as I found that their stories didn't always agree with one another. And so I tried to do what sociologists call triangulation, like getting multiple people to verify some particular scene or facts. And in some of the scenes, there were many people there. And so I did my best.
I want to tackle the first layer with you, which is just if you can help us understand a little bit. The US Patent Office had been issuing patents on human genes for 25 years. And some estimates suggested 20% of the human genome itself was patented. So at that first layer of the onion, can you help us understand why human genes are even considered patentable in the first place?
Yes, it's a little bit counterintuitive, but the Patent Act covers inventions, right? So anything, any machine, manufacture, or composition of matter, right, can be patented. And what's a composition of matter? Generally, it's a new material. So a metallic alloy, right? A stronger type of steel, or more recently, a new polymer, or some kind of nano material, right? All of these things are inventions. People create them, and they can be patented. In 1980, we encountered the first case where a living organism was considered under this statute. And this was a bacterium that a scientist named Anant Chakrabarty, who worked for an oil company, developed as a chemist in order to break down oil spills. He took a normal bacterium and inserted into it some DNA fragments of plasmids that made petrochemicals more attracted to it, right? Or that attracted the bacteria to petrochemicals. And so this actually worked. This is still what we do in some degree when there's an oil spill in the Gulf. We spray this bacterial substance over to break it down. And in a divided opinion, a 5-4 Supreme Court decision, the court ruled that yes, it's a living organism, but it was created by people, and so it could be patented. New creation. So shortly after that case in 1980, the science of genetics started to advance to a degree that we could identify specific genes within a DNA strand, whether it's human or animal, mouse, you name it. By the late 80s, the gene hunters, as they were called back then, were having some success, right? They discovered genes strongly linked to diseases like cystic fibrosis, and those genes had significant medical utility, medical consequences. And so the question was, well, could you patent such a gene? And the answer was, here's what we did. We identified this gene, but we also took it outside of the cellular nucleus where it was located. We extracted it from the chromosome on which it was situated. So as I'm sure most people in the audience know, we have 23 chromosomes, each of which is made of DNA, and each of which contains thousands of different genes that are distributed along the chromosome. The chromosome is huge, and it's actually, quite a difficult task, or at least it was in the 80s and 90s, to identify a particular gene on the chromosome. So what the early gene hunters did to do this, they isolated those genes from the chromosome, meaning they yanked it out of the chromosome, chemically speaking, right? And they purified it so that you end up with a test tube full of this gene and not all of the other stuff in it. And that isolated, purified gene outside of the body is what they patented. They argued to the patent office that, look, this is new. It's not a product of nature. It's not, this isolated gene does not exist in the human body. In the human body, it's within a cellular nucleus on this long strand of DNA that's undifferentiated. You know, if you just looked at a chromosome under the microscope, you wouldn't know where gene 1 began and gene 2, or gene 1 ended and gene 2 began. That you have to do as, you know, as a researcher. And so they were able to argue to the patent office that this isolated, purified gene doesn't exist in nature, therefore it's a creation of humans. It's not a product of nature, it's a man-made composition, and just like a new metallic alloy or rayon or polyester, it's a new creation that can be patented. And the patent office agreed. And that became policy, and that policy was challenged initially, but over the years it became very entrenched. And yeah, as you said, by 2005, about 20% of human genes were subject to some kind of patent protection.
If you can help us understand a little bit about the both sides, the standard patent story that we hear, who benefits, why are they good, who's defending them? And then on the other side, what's the alternative view? What are the harms, and who's the band of advocates that are coming together? Can you kind of, you know, place this in a bit of context for us about who benefits and who harms here?
Sure, absolutely. You know, it's interesting because there are a lot of layers to this story. You know, at the very, very outer level, there's this doctrinal question, right? Is a human gene, does it fall under this product of nature exception to the patent laws? And there are cases going back for a century about what sort of things do qualify and what don't. But that question, of course, it was argued in the cases, but really people were talking about other issues in this case, right? And so the people who supported these patents, the biotech industry, the patent office, most of the patent bar, you know, they were talking about why we have patents and why patents are important and why courts should interpret this doctrine so that you can patent human genes. And the reason, at least the heart of the reason, is an incentive story, right? So the patent law is baked into the US Constitution. Surprisingly enough, it's not part of the Bill of Rights. It is part of the enumerated powers of Congress in Article 1, Section 8, Clause 8. It says Congress has the power to establish laws to issue patents, right? And they're issued to promote the progress of science and the useful arts. It's this utilitarian purpose. We want patents because we want more inventions, and people will make more inventions, the theory goes, if they get a reward. And the reward for making a new invention is that if you get a patent, you, at least today, for 20 years, are the only one who has the right to make, use, or sell that invention in the United States. I actually, you know, like most scholars in this area, I buy that incentive story in many cases. Things like new drugs. There are estimates that a new cancer drug costs between $700 million and $2 billion to bring to market when you take all of the failed you know, drug candidates and testing and clinical trials that you have to go through. It's expensive, and nobody would invest that kind of money if there weren't some financial payoff at the end. A small molecule drug is pretty easy to copy, and so without that exclusivity that the law gives you, you're not going to be able to recoup your expenses. And you know, there are lots of arguments about drug pricing and so forth. And so the theory was, look, discovering these genes does cost money. It takes a lot of effort. We want to incentivize discovering these genes, you know, finding the association between this gene and cystic fibrosis, breast cancer, you name it. This is important for medicine. And so we want that to happen. And so we need patents to do that. If you don't have patents, it's not going to happen and public health will suffer. Right? That's the baseline argument. The story is a little bit different here. In the case of BRCA, the story is very different. And in the case of genes in general, it's different. Like BRCA, the discovery of the BRCA gene back in BRCA1 back in 1994 itself is an amazing and interesting story. There are 2 books that were written back in the 90s about this race to find the breast cancer gene. A well-known genetic epidemiologist at Berkeley, who's now at the University of Washington, through genetic epidemiology methods was able to isolate some gene that had a strong hereditary influence on breast cancer. That was like the firing gun in a race that set off competing laboratory groups around the world, about a dozen of them, looking to find the actual gene. And so labs competed to do this. The University of Utah, which happens to be the university where I am speaking to you from, was deeply involved in this gene hunting business back in the 80s and 90s. Researchers at Utah had discovered genes that were linked to a number of rare but still very important diseases before this. And so University of Utah put together actually 2 competing teams formed there to find this breast cancer gene. One of those teams stayed within the university. The other team formed a company. And that's the company that became Myriad Genetics. And Myriad, through some very strategic business dealings, going back through the patent history of this, you'll see patents filed by everybody on sort of leads, right? Berkeley had filed patents, even Utah had filed patents on false leads, but the Myriad team actually discovered it, patented it, or applied for the patent, before they made the announcement and locked up the rights. And the argument, the counter argument to the incentive argument is, look, you didn't need the patent to discover the gene. If Myriad hadn't discovered that gene, it would have been discovered a few weeks later by one of these other groups. And so the patent, though, the incentive motivation wasn't there, right? That gene would have been discovered. It was discovered by a competing group. So it kind of goes away. Others, James Watson, who of course won the Nobel Prize for co-discovering the chemical structure of DNA, was avidly against these gene patents. In his view, and the view of many scientists, you shouldn't be able to patent these because it's so easy to find them. Anybody could find them. If you simply applied enough effort, after a certain amount of time, you would find them. I've interviewed many of the scientists, or not many, I've interviewed a few of the scientists from Myriad who actually make a case that they actually did have some technological skill.
It's very complicated, and there are, as you say, a lot of background backflips and intellectual moves here to kind of defend or deny the existence of patents. But I'm wondering, so Myriad wins, what happens? And, what are the outcomes for women themselves once Myriad has these patents? Can you tell us a bit about the other side?
Yeah, absolutely. And that's where this really becomes a human story as opposed to a science story or a business story, right? So these early gene patents were there, but they really flew under the radar screen because they had no commercial impact. This was just sort of a nice sort of a scientific victory and scientific recognition. Myriad's patents started to issue in 1997, right? They sequenced in 94. It took a few years. It always takes a few years to get these through the patent office. As soon as the patents started to issue in 97 and 98, Myriad started to shut down these other groups. It sent out these very threatening sounding cease and desist letters from big law firms. It actually sued University of Pennsylvania, who was ignoring those letters, so to speak. And by 2000, this enforcement campaign had basically cleared the market of every other testing center who had the capability to test for BRCA mutations, leaving Myriad as the only game in town. And as the only game in town, as any economics 101 student will tell you, that means you can be a monopolist, and a monopolist can charge whatever they want for their product. And that's what Myriad did, right? They did a very intelligent analysis of the market and figured, that they could charge at that time $2,600. That went up to over $3,000 over the years for the test, and people would pay for it. The problem was that it was difficult to get insurance to cover that test, certainly at that price point. Right, so you go to the doctor today and you get a cholesterol test and so forth. That's like $50. And insurance generally pays for those preventative, sort of wellness tests. But a $3,000 test is a different matter, especially if, as Myriad thought, every woman in America should get that test. And so there ensued a lengthy fight and set of negotiations with carriers, with Medicare, Medicaid, CMS, who controls those agencies, over whether they would cover the test. And it took a long time, and even during the course of this book, the events narrated in this book, Medicaid never agreed to pay the price because you have young women who are on Medicaid who can't get the test. You also have women whose insurance carriers just haven't agreed to cover it yet, who have perfectly fine and good policies who won't cover it. And then you have women who have policies who might cover the test, but only if you meet very stringent conditions. In Myriad's view, everyone should get this test. Every carrier should cover the test, and they should just, they should be making money off of every person in America. And they did some controversial things like advertise their test on TV to encourage women to ask their doctors about getting this test. That was viewed with very mixed reactions in a lot of areas. But you end up with a large pool of women who cannot get tested. And what does this mean? If you have one of these BRCA mutations, your lifetime risk of contracting breast or ovarian cancer is very high, much higher than the population average, something like 8 to 10 times higher, depending on which mutation you have. So that's a huge, and the lifetime risk of getting breast cancer in the US is relatively high as it is. So you have women who have like an 80% chance of getting this over their lifetime. And so you could reduce your chances significantly of contracting these diseases if you knew that you had tested positive for these mutations. One of the cases I describe in the book is, I think, so important, the case of Kathleen Maxian and her sister Eileen Kelly, because they could afford these tests. They could just pay out of pocket, and they were fortunate enough to be able to afford these tests without insurance, but you couldn't get the test, right? This was part of the bargain that Myriad struck with the insurance agencies. They would only run the tests if women met these very strict qualification criteria because insurance companies didn't want to be paying for a lot of tests for the entire population.
Women were harmed. I mean, we don't know how many, but there were real harms in terms of people being unable to get this information, even if they could afford it, or being denied the ability to even access the test because insurance wouldn't cover it, or this kind of thing. And so I wonder if you can, I want to sort of switch tacks a little, thinking about the human element here and why breast cancer, and the kind of importance here of why this issue. I mean, I think, as you say, Myriad is one of the first companies to do this, and they're commercializing and advertising broadly. But there's another element around the disease itself and the fact that this is breast cancer, and why that sort of captures the public imagination. And you even note in the book that there are other diseases like Canavan, less well known, that have actually harmed patient advocate groups have been harmed by patents. But I wonder if you can just talk a little bit about breast cancer and how that is sort of also a really important part of the story.
Yeah. It's a really remarkable aspect of this litigation, I found. like you said, thousands of genes are patented. Most of them are on diseases most of us have never heard of. That doesn't mean that they're not deadly and that people don't die from them, but they just don't have the attention. I mean, there is no disease probably in the United States that has as much advocacy, attention focused on it as breast cancer. AIDS probably at one point in our history was, but I think breast cancer again has surpassed even AIDS, right? Yes. Just as a legal matter, as a lawyer, the patent system shouldn't be used to get patents on genes that are, created and live inside the human body. So at the very outset, this wasn't about breast cancer. It was about this principle of patent law and how it was being misused. But the ACLU, they're thorough and they are a remarkable litigation machine, right? They are probably the oldest and most prestigious civil rights public interest litigation outfit in the US. Everybody in America knows, either has had breast cancer or knows somebody, has a close relative who's had breast cancer, myself included. I think that's probably true of everyone. And it's not just members of the public, but judges, judges, jurors, everybody out there knows, and it strikes a personal chord. And that, again, it sounds very mercenary, but it is the way that a civil rights lawsuit, gets constructed. It's done very, very carefully. And the ACLU decided we will do this the ACLU way, which is, a full on with a lot of public outreach, a lot of public information, and pick a disease that really strikes a chord.
And as you say, I mean, it really is part of the sort of social and complex story here, that breast cancer was part of what helped capture the public imagination, given there were these other stories which seem shocking to read about when you hear them, people being denied these tests and children dying. But, it's sort of the need, as you say, to find the right disease here to really capture the attention of the public is also so interesting. I want to ask you if you can comment briefly on how you think this is a story also that's US specific, and what this story really, and as I'd mentioned, I did my PhD in the UK on BRCA mutations among Ashkenazi Jewish women, where the patents were not in existence, although actually Myriad was trying to also uphold them there. And so I'm thinking of things, which you mentioned in the book, like the US healthcare system, licensing, university licensing, or just kind of American values, and how this story is also a US specific story, a story about the US as well, and just sort of helping us understand that a bit.
The disease is a global disease. And the genes they exist around the world. And patents, Myriad and various institutions tried to get patents around the world. And in some countries, they've been successful. And there's been litigation. I mentioned in the introduction, like the book would be 3 times as long if I tried to cover the entire world here. Australia had a lot of litigation around these patents and these genes. In the UK, that group out of Imperial College London, got their patent first. But the combination of the way the US healthcare system works, the way the payment system works, the way the patent system works with these very broad patents. So patents issued in Europe, but only in a very narrow way. Only, I mean, maybe still too broad, but much narrower in the US. So in Europe, the patents issued on like the association between these particular mutations and breast and ovarian cancer, which again is still like a big thing. In the US, the patents covered the genes as compositions of matter, right? Just like the new metallic alloy. If you invent a new type of steel, anything you do with that steel, anything you make is covered by your patent, right? Using that steel to make an airplane wing or a boat hull or a new type of pencil, all of that is covered because you created the material. With the gene, that makes no sense, but we allow that in the US.
Can you actually talk about exactly this question, which has not really been talked about ever before, but this battle going on within the government administration itself, and how it is that the government is kind of caught in the middle here and ends up siding more arguably on the side of the ACLU and going against a 25-year precedent of their very own patent office. So can you also,
Yeah, going against the government, right?
Correct.
How did that happen? That was one of the most peculiar things about this case, right? So obviously you've got Myriad is fighting its fight and the ACLU is fighting its fight, but the US government is kind of a third party at almost every stage of this litigation. So at first the ACLU sued the patent office along with Myriad, but that part of the case got dismissed very early on. And so the patent office was not part of the litigation. But they still wanted to be involved, right? They justifiably felt that they were doing the right thing. They were following the law as it existed. And so, as often happens when there's a government agency's rules that are involved in a case, the agency steps forward in the litigation and gives its position. This happens all the time. Eventually, the Department of Justice sided mostly with the ACLU, but did create this Solomonic compromise where they argued that, look, genomic DNA, the way the sequence exists in your cells should not be patentable. That is like a natural element that you discover in nature, like a mineral that you dig out of the earth. You can't patent it that way. But if there's some change that gets made or something gets created in the lab that doesn't exist in nature, well, then you can patent it. These so-called complementary DNA or cDNA constructs, which Myriad wasn't actually using or creating and are not useful to the diagnostics process. But again, because Myriad had a good patent lawyer, they claimed those in their patents anyway, because they might be useful someday. If nothing else, they could license them to somebody else. So those claims, the Department of Justice argued, those should be allowed. And the Department of Justice wrote a brief saying that. And at the Intermediate Appeals Court, for the first time ever in history, the acting Solicitor General of the United States went over to the Federal Court of Appeals and argued in person in that case. I have talked to that individual. The Solicitor General, I think, never even really knew where that court was located. It's a little hard to find. But, he went over and did it himself, which had never happened before. And then, of course, at the Supreme Court, this Solicitor General's brief was sort of entirely what the Supreme Court adopted as its opinion, wholesale, in a 9-0 opinion. So it was extremely influential.
Yeah, so fascinating. And as you say, you really do have this insight into what's happening behind the scenes that we get through the book. So, and as you said, the government sort of compromise position is ultimately the position that wins, and most of Myriad's patents are struck down. So what have I just sort of now, turning a little more future thinking, what have the implications of that case been?
So Myriad is fine. They are still, they're just down the street. And I mean, one thing about Myriad, they're viewed as, this BRCA diagnostic company. They had many other products and many other diagnostic tests. They do a lot of other things. And in fact, if you talk to genetic counselors today, and many of them will still tell you that the Myriad test is still the gold standard. They will recommend to their patients that they get the Myriad test. And the price was reduced. I mean, that's the main thing that happened in this market as a result of the case. So literally the day of the Supreme Court decision, other testing companies announced, we're now offering BRCA testing at half the price. Right, and that happened, and the price, as a result of market competition now, the price has gone down.
So, lastly, really just to wrap up, I want to ask you, what you think, given this potential threat and, as you say, flip-flop in the law, what if anything, do you think are sort of top priorities or key things we should do to ensure justice and access to genetic testing and research going forward? And are there any key things you think, whether it's as academics, researchers, the public, that we should really either be focusing on or that need to change going forward?
One thing I try to show in the book is that this isn't just patents. I mean, healthcare, the healthcare system in this country, it's strange and doesn't work all that well, and the reimbursement system, could use a lot of help. The fact that the Medicaid systems of all 50 states sort of operate independently and can decide they don't want to pay for something. We have no price controls on anything. When you look back and see this $3,000 test, that sounds expensive. But then when you see that, like, the latest gene therapies are priced at $2 million a pop, it looks like we're talking, like pocket change here. And so healthcare pricing and so forth is very out of control. Companies do recoup their expenses very quickly these days through the US market, potentially subsidizing costs in other countries, like every other country that has governmental price controls on drugs. And so it's an unfair burden on the American taxpayers to some degree, and to the American system and patients. And so, again, many books have been written about this, and I do cite some of them in my book, but there's just a lot of work that needs to be done around access in healthcare.
Yep. But this is one very important piece and a very important, I think, story that you've unfolded, that you've told us, that you've helped us understand, and also told it in such a rich and engaging way. So, I just want to say thank you again for writing this terrific book, which is sitting right here, The Genome Defense. And also it's available at Left Bank Books, exactly. So thank you very much, George. This was terrific. Thank you so very much.
Jessica, thank you. No, it's been a real pleasure. Thanks for reading, and thanks for the conversation.